been adopted by council and our administrative questions being cleared up, the city then asked us to adopt a contribution rate today. While there was lack of clarity, we had some trouble figuring out how to do that, I understand, but now with the clarity, we have Bill Hallmark from Chiron, our actuary. Bill, are you there?
Yeah, I'm here.
Yeah, Bill is there, but if you allow me, Mr. Chair, I'd like to comment on Bill being on the phone. Obviously, there were some communications between the city and our office in that particular item, and so there were some options that were provided in the communication by the city, and so in any event, we discussed those options with the actuary, and that's what you're going to hear Bill this morning discuss, which is the recommendation on moving forward in the interim with approving the current Tier 1 normal cost contribution rates for Tier 1 members for any new Tier 2 member, while Chiron has the opportunity to do their own calculations and come back to your board with the recommended contribution rate for Tier 2. With that said, I'll turn it over to Bill.
Thanks, Roberto. I think it's clear that we have a need for an interim contribution rate while the members, because of the effective date of Tier 2 and the timing for us to put together a calculation of a new contribution rate and get it approved by the board, presented to the board and approved. So we've recommended for an interim contribution rate to use the current rate that is charged for Tier 1 members of 11.65% of pay. That rate represents 3/11 of the current Tier 1 normal cost, plus there's a very small UAL piece for a prior plan amendment. Tier 2 members, they're supposed to pay 50% of the normal cost. There wouldn't be any UAL for them starting out. And so we did not do any calculations, but looked at what the changes in the benefits were, the change in benefit formula, the change in eligibility age for retirement, the lower COLA, and other changes. And then we also looked at the analysis that was done by the city's actuary on Tier 2. And as a result, we think the 11.65% is in the ballpark and is a reasonable rate to use in the interim. So we're recommending that. Now, I do also want to address how we would handle the city's contributions. For this fiscal year, the city has already prepaid their contribution. They make their payment on or about July 1st for the coming year. And so we have this same situation with the federated Tier 2, and we're recommending the same approach, which is that at the end of this fiscal year, we look at the accumulated member contributions with interest and transfer an amount from the city's Tier 1 account equal to that amount into the Tier 2 account, so that the city and member accounts are identical at the end of the year. And that would, I think, comply with the intention of Tier 2 that each side is paying 50% of the cost for that first year. So with that, let me take any questions on that recommendation, and then I'll talk about putting together the ongoing rate for Tier 2.
So I'll start with two questions. 3/11 was 11.65%. So you're saying the 50-50 would be 21% for the city and 21% for the member?
No, the 50-50, we're saying start out with 11.65 for each. So we're not using the Tier 1 normal cost. We're using the member rate.
So in the member rate in the current plan, the 3/11 of the total cost is 11.65, and you're saying 11.65 is probably roughly what 50/50 would be of the cost of the new plan.
Correct.
Okay, thank you. That was my question. And this is based on your analysis. You're going through the best estimate in the ballpark, interim rate, your own analysis and calculations as a independent recommendation to this board.
Yes, although I want to emphasize we haven't done any calculations. It's our independent judgment looking at the different factors that have changed and kind of providing rule of thumb type estimates to adjustments to get there. And so we think that the 11.65 gets us in the ballpark. When we do the actual calculations, it undoubtedly will be a different number than 11.65.
Trustee Sinceri.
Bill, earlier in the conversation when Harvey was talking about the apportionment of administration cost and how complicated that can be, and here's a new plan starting up that has costs that are apportioned but yet really doesn't have much in assets, how do you account for that?
I think at this point we would be applying, the administrative costs are a fixed dollar amount that we have assumed and tied to payroll. So we would probably apportion them by payroll.
Bill, I think that it's important to address the issue once you come back to the board with the recommended rate. Undoubtedly, it's going to be different. Even if it's similar to 1165, it may be a bit off, which require then some adjustment to be made. So can you address that issue? I assume that when you come back to the board, you will provide two things. You will provide, okay, this is the actual Tier 2 rate that we should be charging. And then you're also going to be talking about, but because we have these 2 months, presumably, of 11.65, and this is the actual rate, then this is the adjustment. So maybe are you going to suggest that we, for the remainder of the year, we charge this different rate to make up for the difference? Do you have any comments on how to address that?
Yeah, so we're anticipating that we would come back for the October meeting with recommendations on rates. So you would have approximately 2 months of potential Tier 2 members who would have paid the interim rate. From an actuarial perspective, the amount that the interim rate differs from the permanent rate is not going to be material as we go forward, but there is a sense of fairness for those individual members. And so it becomes a question of what is the easiest administrative method for making that correction. And we can look at the total payroll that is paid and the difference and see what the best options are for correction. There could be, if it's a small amount, I think you could consider a single adjustment. If it's a larger amount, you may want to spread it over a few months, but it would only affect those members who were hired in the first 2 months. And I'd suggest that we bring that back at the time.
All right. Thank you.
So the one thing I do notice in looking at all this and hearing this is we're really talking about 2 separate sets of assets, returns, costs, unfunded liabilities need to be kept separately because each of the 2 people will be paying for it in different ways. Are we set up to do that, or is that the plan? We're going to make that all happen?
No, we're not. I like to have further discussions on that. I know this is council raised that issue yesterday when we had a conference call. We certainly can set it up. There are going to be some implications if we have to keep separate accounting, but I mean, certainly can be done. I'm not sure about the actual assets of the plan. We can keep separate accounting for the costs associated with it, but
I thought it was an actuarial administrative cost that we had to keep separately like we do for the Tier 2 for Federated. I'm not sure if it's an accounting GL separate cost that you're talking about. That's a new concept to me.
yeah.
But
I just assume
actuarially,
it's
the
gonna-
administrative cost is already split on the Federated side.
I just assume it's going to be similar to the federated tier 2.
Well, that's what I need to find out if
Yeah,
it's different.
it's going to have to be split between Tier 1 and Tier 2.
Right, but not on a GL basis. It's actuarially based in the fixed
An
in the
apportionment
cost.
of the cost.
Apportioned in the actuarial cost. That's, I don't know, Jennifer, do you have an answer for that?
Jennifer Shembri, Deputy
Yeah.
Director of Employee Relations.
Thank
I just
you.
wanted to note we've had the federated second tier in place since September 2012, and the same issue is the same in that one. So however it's being done in federated, we should do the same in place in 5.
Yeah. It's done in the actuarial way that Bill mentioned. It's not done on a daily GL basis.
Right, there's not an
Okay.
accounting line item that says charge to this code, this money split this way.
It's the way we add the administrative cost into the contribution rates.
Okay, in that case, we're all set. From the administrative standpoint.
Bill, are you all set?
It's going to take,
I think it's something that can be worked out. I thought that we were just allocating when the contributions come in, that the record-keeping or administration system was allocating those to the appropriate tiers and appropriate buckets within
That is
the
correct.
tier.
we
And
don't-
Right, that is correct.
The earnings were being allocated in proportion to the assets in that tier.
Yes,
That's
we
correct.
actually do that, and so I guess the issue would be when we come back to the board to discuss those issues, we're gonna have some assumptions that Kyron's going to recommend to the board, and then we'll have to decide if those are the right assumptions, so that you can do the apportionment and keep track of those tier 1 and 2 separately. Does that make sense?
Yes.
Okay.
Are there any other comments or, no? Public comments or?
Thank you, Chairman Caldor. Trustees, my name's Greg Adam. I'm General Counsel for the San Jose Police Officers Association. And I've got a few general comments, and then I have some specific comments. As a general proposition, we're implementing here what originally was an agreement. There was an arbitration, there's an arbitrator's award. It's agreement that flows from what happened in Measure B, because Measure B sets certain maximums for Tier 2 benefits. And as we met with the city after the passage of Measure B, the city took the position that really there was nothing to negotiate, and actually refused to meet with us to talk about Tier 2 until very late in the process. That was notwithstanding the POA making it clear that it was not contesting what was in Measure B, and actually suggesting that we have a meeting involving the city, the POA, and representatives of the retirement board so that we could work out some of the very same questions that are appearing in Mr. Liederman's correspondence, in the Chiron correspondence, i.e. the nuts and bolts of how you put this new tier together. Because Measure B covers certain things with respect to the new tier, basically setting what the level of benefits will be. The rest of setting up the plan is basically left, is not covered by Measure B. So it turned out that only months later, so again, we start in October requesting a meeting to try and negotiate, hammer out a full agreement. It took until late April, about a week or so before we were actually headed to the arbitrator, for the city to actually start discussing with us the specifics of what ended up in this agreement. Now, there ended up being basically 1.5 meetings in which we were able to hammer out certain details. And that's amongst the 5 pages that you see in front of you. But even as we signed off on the agreement in front of the arbitrator in this very room, we still had a ton of questions in terms of how this system, this new Tier 2, would be implemented. And we felt there were an awful lot of unanswered questions on major elements of this plan, such as the city's position that basically there appears to be no vested rights in the plan, and that the city can reduce benefits while you're an employee, can reduce benefits presumably while you're still a retiree. And in fact, I see those questions reappearing within the Chiron letter, and I don't see they've yet been answered by the city, which leaves us going into a retirement plan in a very half-baked, haphazard kind of a manner. And this is complicated stuff. I heard earlier how many meetings this body has to hold, either this body or its committees, to administer these issues. And the POA's perspective is we've entered an agreement, and to the extent we are implementing the agreement, we absolutely support that because we've got an obligation to under this agreement. There's no doubt we think it's a lousy benefit, but the voters have spoken. But the concern that I'm trying to summarize, and I'll go through some specifics, is where there are no specifics in the agreement. What we're seeing is in the ordinance an effort by the city to fill in the gaps unilaterally. Unlike the agreement, which is a bilateral document, both sides came together and signed off on this. The ordinance that the city's created is solely been carried out by the city. The POA's been sent a copy, sure, but in terms of being part of the writing of it or the city's legislative process putting together, we haven't been part of it, which means that really our opportunity to come and comment on what we're seeing in the ordinance is before this body. So there are many areas where we agree with the city. We agree that compensation is just base pay. That's it. Nothing else. No premiums. Base pay. Kind of going through the issues in Harvey's letter and the clarifications and answers. On the second issue, in terms of the pension calculations, again, we agree with the city. On the question of what happens between ages of 50 and 60 under the row titled age eligibility, we think that should be whatever the actuaries determine is the fairest method. It shouldn't favor the employee or the city. With respect to the COLA issue, that's the fourth issue in Mr. Liederman's letter, the city takes the position that the COLA for Tier 2 would be subject to the emergency suspension provisions of Measure B. But as I discussed with Ms. Shembri this morning, and I will acknowledge that Ms. Shembri has indicated the city is now willing to sit down and talk with us about the POA's concerns, and I'm heartened by that, but it seems to, I think we're kind of got the process in reverse. Ideally, this would have happened a year ago, and again, it was a year, October 2012, we reached out to have three-party discussions involving representatives of this body to try to put together a better product. Back to the COLA, the Measure B says that the emergency measures, this is 1510A of Measure B, it says they apply to retirees. And it defines retirees as current and future retirees employed as of the effective date of this Act. So that specifically limits the application of the emergency measures to people who were employed on June 6, 2012. And yet in the city's response to Mr. Liederman, I'm seeing the city saying that, no, it does apply to Tier 2 people. Of course, Tier 2 people were not employed June 6th of 2012. We agree with the city on disability retirements, and as the definition is stated in Measure B. We agree with the city on survivorship benefits, that it's the earlier of age 18 or when a child gets married / enters a domestic partnership. On the second question on survivorship benefits, however, we disagree. The city simply has the word no in response to the question of does the child benefit have to be the actuarial equivalent? And we believe that page 3, paragraph 3 of the arbitrator's award directly speaks to this issue. Harvey mentioned the on-duty issue, and I think the POA has a disagreement on that question. As we know, police officers in the state of California have peace officer status and responsibilities 24/7, which means at any time, whether you're off duty or at home or on the streets or even if you're doing a pay job, because in San Jose we have certain circumstances where police officers work pay jobs for outside vendors, are essentially performing their normal law enforcement duties, but could be called into action where they have to fully become San Jose officers at any second. Those are the kind of circumstances where the city's current pay practices doesn't really recognize this on-duty status, although indisputably, if an officer either off-duty in Santana Row shopping with his or her spouse or working a pay job, she may be called to spring into action at any second. And our belief is that certainly would qualify as on duty for purposes of disability retirement. And I think that's a little bit inconsistent with what the city's position seems to be. On the return of contributions, we agree with the city. It's intended to include interest the same as Tier 1. On the defined contribution plan, we again agree with the city, and we would note that the city is prohibited from paying more than 9% under any other circumstance than the 2% at 60 benefit that's in Measure B and is now part of this agreement. We agree that it includes all costs. Harvey's letter asked about health care subsidies, and our view is that the retiree health care component is separate and apart on the all costs because the Tier 2 employees will be paying exactly the same contribution towards retiree health care as their colleagues in Tier 1. So I didn't see the city specifically answer that question. We believe the retiree health care costs are separate and really still covered by the master collective bargaining agreement between the city and the POA.
So, just for sake of time, it seems there's a number of areas where there's disagreement about the city's interpretation of the municipal code and police officers' interpretation as the code having implemented the agreement that was put in place. From the city's perspective, do you think there was agreement on those areas, or are the empty spots being filled in, or what's your response?
Again, Jennifer Shembri, Deputy Director of Employee Relations. A couple of responses to that. I do want to just point out at the very beginning that the city has a different version of the events leading up to the agreement that was reached, not surprising. I don't think it's useful to get into here, and I don't think it's really relevant to the board's actions here. But I do want to point that out. Our agreement was reached in April, and prior to that, weeks prior to that, we did provide the POA a draft of the ordinance. So as we were negotiating this benefit, they had a draft of the full ordinance. It subsequently did change because our final agreement was different, but they did have a draft as we were negotiating with a lot of these details, the majority of these details. After that, we reached the agreement in April. As soon as the draft ordinances were finalized, prior to them going to the City Council, I provided them to Jim Munland in an email, asking him if he had any questions and concerns. That was our attempt to get the POA involved in the drafting of the ordinances, to see if there were any disagreements on what we negotiated versus what was in the ordinance. And this morning was the first that the city heard that the POA had concerns. So they did have from May until now to let us know of any concerns with the draft ordinances, even prior to the council adopting them. And again, this morning was the first we heard. That said, I had a conversation with Greg this morning. We are happy to meet with the POA to talk about their concerns. If changes need to be made to the ordinances, we can subsequently bring them back, as we talked about earlier, when we bring back any other technical changes to the ordinances that need to be made. So we're happy to sit down and talk about these issues.
We welcome that opportunity. Again, I kind of wish it had happened beforehand rather than afterwards. I guess one concern that the POA's articulated is in terms of calculating what the Tier 2 employees are going to be done in a kind of temporary manner. It sounds like I thought I heard the actuary state there really haven't been any calculations done. Undoubtedly, it's going to be different numbers, and there are going to be adjustments. I think because it's such an unusual way of doing things, it's causing some concern in the POA about why we're doing it in that manner.
Are there employees who are going to be onboarded into this Tier 2 plan between now and when we'd have our next meeting, when perhaps we could have our actuary do the calculations?
Between the August and September?
Yes.
Probably very few. It would only be rehires because we have an academy that's not going to graduate in that month period, so they would not be going into Tier 2. So it would be only any rehires coming back into the police department that would go into Tier 2. So it would be very few.
But there are some?
I don't know of
I'm sorry.
any.
That's fine.
Yeah, but there could be.
Okay. Harvey? So it seems, if I look at it, it seems there's an ordinance and there's a contribution rate. In the ordinance, if there's issues that the POA has with the ordinance, they should be asking the city to resolve that or pursue the court route to do that, but we're obligated to follow the ordinance. If there's interpretation issues, I don't know how to resolve an interpretation issue. If they're saying this is what it means, do they need to put that into the ordinance and then the POA can pursue it that way, or do we wait until someone tries to interpret it one way or the other way, and then there's a process that starts?
There are always going to be interpretation issues over any plan document that sets forth benefits. It's highly complicated. Members are going to have different readings of the law, and as we are, we're going to try to administer it as best we can. If there are additional issues, I think staff will have to reach out to both, to all interested parties, whether it's the POA and the city, to say, what does this mean? Have we got this right? Do we understand the intent here? Ultimately, we're going to have to take our best shot at it. As I say, I think we've resolved 80% of the interpretation questions that we had just to understand this. And so I think we have enough that we can do a pretty good job of administering it. But as always, there are going to be some issues that come up. We're trying to anticipate what may happen and what disputes may arise so that we can avoid them in the future if we possibly can. If there's going to be some technical cleanup, it'd be nice if all the interested parties got together to work on the language of that so we get that inked properly. Ultimately, it's a highly complex document, a highly complex plan, and there's going to be interpretation issues that come up from time to time. Let's try to put to bed 95% of those so we only have to deal with 5% in the future. The members need to know what they got, and our staff in this board needs to know what we're supposed to be administering, and our actuary needs to be able to make a recommendation on how to price the whole thing. So as much clarity we can get, the better off we're going to be.
Trustee Rounds and Trustee Lanza.
I apologize because I'm a bit confused. But are we being asked to set a rate today?
No.
Yes.
I'm sorry, yes. You're
One
right.
said yes? Yeah, okay.
Yes.
And then that rate will change within the next few weeks
Couple of
or
months.
months?
Couple of months.
Months? So
Yes.
then the people, however many are onboarded, will be onboarded with this interim rate, and then it has to go back and get readjusted for them some way or another. So they don't, in fact, know what's really, okay.
That's right.
Can I clarify one thing? Because you would ask me between August and September, but I understand there's discussion of setting the rate in October.
I was going to see if he could come back in September, but
Okay.
his initial thing was that it would be October before.
We would prefer September, and if you do the October meeting, then there is an academy
Academy.
graduating in September, so there would be a lot more people going into Tier 2.
We prefer September too.
Okay.
Bill, do you hear that?
Yeah, I'm hearing that.
So Bill, you could come back to us in September with some calculations and a better thought estimate of the contribution rate?
Yeah, I think we can come back with some better thought. I was hesitant to commit to September, although I had told Roberto we would be trying to push this as quickly as possible and try and get back then, but that will be pressing us. I guess the thought that there will be rehires made in August, I guess, pushes me to want some additional clarification on some of our rehire questions, and then I think there are some follow-up questions on that.
So I'm happy to work with you as much as possible to address those issues, and obviously with the city and all the stakeholders, to try to give you as much information as you need to the extent that you can to come back in September with a rate. So we will try as best as we can to accommodate that.
Trustee Lanza, then Trustee Mason.
So this board has two standing policies, and obviously something is very broken here, and so we're going to need to react to that. One of our standing policies, which we established about 18 months ago, is that when the city puts forward an ordinance, we will enact that. We will not challenge their ordinances. We will not engage politically. They are our masters, and we will react to that. But there was a second piece of that we enacted in consultation with both the city manager and the mayor, and this is the piece that's broken. And that second piece was an agreement owing into Measure B that we would coordinate time schedules, especially the recognition that it takes a lot of time for us to actually figure out the algorithms and implement the algorithms, and we know what happens when we get it wrong. So that has failed, clearly. It may have failed on our side, it may have failed on the city side, it may even have failed on the union side. That has failed. So this board needs to come up with a new policy. We had a policy, it doesn't work, it's broken. I would suggest on our next meeting we come up with a new policy. It seems to me the new policy is that we should be proactive. We have been the handmaiden in this, and we have gotten screwed. So this is not going to happen again. We need to be proactive on this and remind the mayor, and remind the city manager, and remind the city council that it is hard, it is complicated, and God is in the details, and don't ask us to flip a light switch on a certain date when we're not ready to go, because all that's going to happen is we're going to come up with the wrong number, because we don't know what the number is, and therefore we're going to go forward for 4, 5, 6 months with the wrong number, and then we're going to have to unwind the wrong number to back to what it really is. And we have history with the city that when we go to unwind stuff, overpayments, underpayments, it is the most painful thing in the universe. We had that understanding with the mayor and the city manager, who at the time got the fact that when we get it wrong, it's very, very painful. So, Sean, I would like to ask that at the September meeting, we put something on the agenda that talks about how is our board going to be proactive so that we can engage the city manager, engage Jennifer, engage Alex, engage the mayor and the council proactively to beg them, to plead with them, right, to do this in a stable, planned, organized fashion so that we're not left with this detritus of a number that's wrong, has been wrong for 6 months, and then we have to go back and correct it because we know. If it wasn't painful to unwind these things, nobody would care. I'm used to the private sector. We get crap wrong all the time. But unwinding in the private sector is easy. Just say, oh, dang, you know what? We've been paying you too little money for the last 6 months. Here's a check. It's over in 15 minutes. But we know what happens when we try to unwind it here. How long have we been going, Sean, on overpayments and underpayments?
3 years.
3 years. So, Donna, right? Something like that? So, if I can ask, I've spoken too much on this already. Let's put it on the September agenda. We need a new policy at this board for how do we engage to try to not let this happen again. Because I know how painful this is going to be for our poor staff. I know how frustrating it's going to be for the retirement people. I know how frustrating it's going to be for the city. It's going to be frustrating for us, and we'll go round and round on it like a dog chasing its tail.
Can I just address one thing on that issue? Mr. Lund, I understand the concern and frustration. I think one of the things that the city had in the history was that we implemented this in Federated. Under, I believe, very similar timelines, and we did not have these same issues. So maybe we mistakenly thought it would go as smoothly as it did there, that Chiron would be able to establish contribution rates at the same time we were working through ordinance questions. So that was just one thing we had in our kind of our history of this issue.
Oh, I think you're right, Jennifer. And, you know, the thing that keeps coming up again and again when I talk to Matt and the guys over at Federated is just something about police and fire plans. They're more complicated. I bet if we looked at the number of pages in the ordinance, there's probably a lot more pages in the police and fire ordinance.
Yeah, so
than there's
we'll
in the
look at
federal
this as a learning opportunity too, from our perspective.
I'm with you, and I'm not trying to denigrate you guys. I mean, I'm beating you up a little bit on this, but only because we had an agreement and it seems to have sort of been ignored. You know, Pete's not here, and I also would chew on Pete, because he's the guy that's supposed to be standing in front of the council saying, hold on, hold on, hold on.
If I may, I just want to, and Jennifer knows this, but I want to make sure that it's understood that I'm always available. I can't speak to what happened with the Federated because I wasn't here then. And if I'm mistaken, you correct me. I think one of the issues was the ordinance. We didn't really quite get the language timely, but I don't know how much different was that with Federated. But that said, whether it's for this tier 2, Jennifer, or presumably, and I want to get ahead of myself, if there's going to be a tier 2 for a fire, I want to make sure that the city understand we are available. Alex and I think, have a very good line, open communication, so I stand ready to meet with the city anytime. I'd much rather we do this sooner rather than later, so that, you know, not only we now have to work on the police tier 2, but if eventually, and I can't speak for the city, if there's going to be a tier 2 for fire, that we start those discussions early so that to avoid this kind of situation. So I just want to make sure that that's clear.
And we did immediately notify the board of the agreement with POA as soon as we reached it. I think within a day, we sent a memo to the board with the agreement.
Okay.
So,
Trustee Mason.
So I'm just curious, and forgive me for my ignorance, but we're being asked to set contributions. So we're required today to set a rate of some sort? And what's the effect if we do not do that today? Either on the implementation or the cost to the plan, or what's the effect of not setting today?
So I think that's what we're talking about. The only people it would affect would be new hires, and the only new hires might be potential rehires, and they're saying they don't know if there are really any potential rehires. So it would probably not be a real problem to wait until September to set the rate.
well, the tier 2 is effective August 4th. So if you don't set a rate, it doesn't mean that tier 2 is not going to go in place. It is effective because the council enacted the ordinance. So any rehires that come in between August 4th and September 4th, if the board doesn't set a rate, we would take no contribution from them, and then that could be a big retroactive contribution we would need to take when the board set the rate. We were trying to avoid that.
If I can jump in, James, I mean, the problem is that we're going to have to fix it downstream. And so I think the right thing for us to do now is to turn to our actuaries and say, give us your best estimate at this point. Because no matter what we come up with, 0, 100%, 11%, we're going to have to fix it later. So we should come up with our best estimate now, it seems to me. We can't, because our first policy is if they tell us to jump, we'll jump. They've told us to jump.
$10. That's what I assumed. I just want to make sure that was clarified and everybody understood that.
Yeah,
If we don't say something today, then what Jennifer pointed out, which is it's going to be a huge retroactive on whoever employee gets hired.
And again, just to that point, I do, obviously Kyron is on the phone, and they have recommended to move ahead with the tier 1, and I will recommend to your board, when we get to that point, everything is equal, that we try very hard to approve a rate as recommended by Kyron.
Trustee Sansari.
We've been going around here for a while on this. I'm going to make a motion that we accept Chiron's recommendation and that we begin with an interim contribution rate of 11.65% for the Tier 2 plan.
So we have a motion. Do we have a second? Second from Trustee Rounds. Discussion.
Yeah. What makes a difference if we wait till September? Is it 21 cents or is it 15 bucks? We don't really know.
Yeah, so
It's somewhere between 0 and 100.
Yeah.
I think the biggest point, which was what I was clarifying with Jennifer, which is if we don't set something today, an employee may have to pay that much more out of their paychecks, which may seem like an insignificant amount, but when you're already making a much smaller paycheck, it's a pretty significant amount to the employee. So I would suggest that we set the rate.
I agree, but I'm saying, is it just one person? We have no idea?
We don't have
Could
any
be
idea
nobody.
of that.
It could be 0 and it could be 10. We just don't know.
Vince, can you just clarify and say employee and employer at 11.65, please?
I think his recommendation was the employee contribution was 11.65.
I thought
Was it both?
It was both.
Yeah, it's both, yes. I just said we're not going to be actually collecting anything from the city right now because they prepay the
Correct.
contribution. But-
Exactly.
But
we
for
still have to-
calculations,
but we still
eventually,
have
They were
to
21.
reconcile
yes, we
at
do
the
have
end
to
of the year.
reconcile that. Yes.
No?
So you modify.
So-
Yes.
So you're amending your own motion. Does the seconder of the motion accept the amendment? The motion is amended to add 11.65 for the city contribution as well. As part of the discussion, my thought is if the city's going to onboard these people anyway and charge them zero, it's a bigger problem than being off by 3 or 4%. I think, respectfully, it's a little bit of the tail wagging the dog when you just create a retirement plan, bring people in on it, and I figured that would be the function of this board to say, here's the rate, and yes, the plan's ready to go, but that rate's better than a zero rate. So. Any other discussion or questions? Seeing none. All those in favor?
Aye.
Any opposed? None opposed. The motion passes unanimously. We will take a 10-minute break, and then we will commence with the disabilities section of our agenda.